Hello, I'm Thomas Jefferson, the third President of the United States. It's Constitution Week, the date every year when the American people celebrate the drafting of the United States Constitution in Philadelphia between May and September of 1787. I was not there. During that time, I was actually serving as the American minister to the court of Louis XVI in France. But I followed the process of the drafting of the United States Constitution with great interest and had several friends inside Independence Hall at Philadelphia who were able to keep me abreast of some of the developments there. I've been asked to respond to a number of questions about the United States Constitution that have been submitted by students of Bismarck State College, and so I will do that now. Where were you, Mr. Jefferson, when the Constitution was written in Philadelphia? I was actually not in this country in the summer of 1787. I departed for Paris on the 5th of August, 1784, and spent 5 years in France, first as a minister plenipotentiary and then effectively as the American ambassador to France. So I was not here during the period when the first Constitution of the United States, the Articles of Confederation, broke down, and it was replaced by that which was drafted in Philadelphia by the Founding Fathers, 55 men that I regarded as demigods, the most illustrious set of scholars and gentlemen that had ever been assembled for the purposes of creating a social compact for a new experimental nation. Had I been in this country in 1787, I doubt that I would have participated in the Constitutional Convention. I'm not fond of gatherings of men in political situations, and I was an exceedingly shy and retired sort of man, really a scholar, happiest at home at Monticello, surrounded by my books and my gardens and my children and grandchildren. I might have been willing to send a draft, a proposed Constitution down the mountain with Mr. Madison to Philadelphia, but even had I been invited to that gathering, I probably would have declined. Did you play any role in advising James Madison, the father of the Constitution? Yes, I did. Madison and I were close friends. In fact, he was my principal political collaborator through life, and we formed a partnership which changed the nature of the American Republic. I served as the third President of the United States, and after that, Mr. Madison served as the fourth for 2 terms, and our mutual friend and protege, James Madison, served as the 5th President of the United States for 2 terms. So the so-called Virginia dynasty served for 24 years in the executive office under the United States Constitution. Mr. Madison wrote to me while I was in Paris saying that he was about to undertake this great challenge and said that it was unclear how one would proceed in creating a written constitution. There were so few precedents, and he wondered if I could give him advice. So I spent a couple of weeks going through the bookshops of Paris and gathered more than 80 books on the histories of constitutions, the histories of the ancient Greek city-states and the Roman Republic and so on, and put together a package of books for him, sent them across the Atlantic Ocean to him, and said, now if you will read these and digest them, you will probably know more than anyone else on earth about the challenge of writing a written constitution. And the thing about Mr. Madison that was always so amazing is that he did this. He actually sat down and read these scores of dense books about constitutions and social compacts and the nature of government, dating all the way back to the ancient world, to Aristotle and to Polybius and Tacitus and Livy. And he didn't just read these books, he took extensive notes and wrote a famous essay called The Vices of Constitutions to show the sorts of things that we should apparently try to avoid in crafting our own. So when he got to Philadelphia in the spring of 1787, Mr. Madison was by far the best prepared man at that event. And because of that, he was able to dominate the proceedings to a considerable degree. It was Madison who created the famous Virginia Plan, which was presented to the Constitution almost at the beginning of its deliberations. And so I suppose I could say that I was the librarian or the bibliographer to the Constitution and was able to get books for Mr. Madison in Europe that he probably could not have obtained, certainly not in any short term, within the United States. Mr. Jefferson, what were your first reactions when you saw the finished Constitution in September of 1787? The men who met in Philadelphia developed a gag rule. They actually produced a code of silence that they would not, outside of Independence Hall, talk about the deliberations within. They felt that their conversations and debates would be freer and more productive if they weren't constantly being watched by the citizens of Philadelphia and Pennsylvania or their constituents back home in the 13 participating states. And so they developed this secrecy rule, which I found somewhat counterproductive to the idea of creating a transparent republic, but I did understand the logic. So it wasn't until the end of the process that I really learned what they had done. I had been following their deliberations with whatever attention one could give from Paris, more than 3,000 miles away, and given the nature of the secrecy rule that they had adopted. But when they had finished in September, I received copies of the new Constitution from 3 friends of mine who were there. Mr. Madison, of course, George Washington, who was the president of the convention, and Dr. Franklin, Benjamin Franklin, the senior statesman and the great old philosopher who participated in the entire set of deliberations in Philadelphia. When I received their drafts, I will admit that I was disappointed, in some ways even appalled. I felt that the good old venerable Articles of Confederation had been an adequate Constitution for the United States. There were certain problems with the Articles of Confederation, principally taxation, but also the nature of the majorities needed to pass amendments to that instrument. But I felt that a couple of good, careful amendments to the fabric of the Articles of Confederation would have been sufficient. Nor did I think that the Founding Fathers who met in Philadelphia had been given the authority to tear up the Articles of Confederation and start fresh. So it troubled me a bit that they had done this sort of extra legal thing. And I was fond of the Articles of Confederation because they really believed that the states were the best authority for our government, that the state of Virginia was a commonwealth, and Maryland was another, and New York a third, and that these were sovereign states that would handle all of their own internal business, but confederate for certain very limited national and international purposes. In short, I believe that Virginia is a more competent sovereign authority to solve the problems of the people of Virginia than any faraway government that one might devise. And so I felt that the new Constitution had made a fundamental mistake in swallowing up the constituent states and creating an overarching authority. It seemed to me too powerful. I said, this is like bringing in a fox to police the hen house. What role, if any, Mr. Jefferson, did you play in the creation of the Bill of Rights? When I received the draft of the new Constitution in Paris from my 3 friends, Franklin, Washington, and James Madison, I was upset for a number of reasons, but principally because the Constitution did not contain a Bill of Rights. We lived in the age of the Enlightenment, in the age of the rights of man, the first time in human history when it was widely understood that people are born with rights, that rights aren't granted to people by generous governments. We are born with inherent rights, and any government that does not enshrine those rights has corrupted natural law. The fact that the Constitution did not contain a Bill of Rights, I found to be an almost fatal challenge to its ratification. I was only angry 2 or 3 times in the whole course of my life, but this, in fact, was one of them. And I wrote a candid letter to Mr. Madison, my closest friend, and said, what every people on earth has a right to expect against its government is a Bill of Rights. This can never be left to inference. It's not implied in this or any other constitution. And any constitution that does not contain a Bill of Rights is under natural law null and void. Mr. Madison was not immediately convinced. He believed that the Bill of Rights would be what he called a parchment guarantee, And he said that if we enumerated a number of natural rights, it might be found later that we had omitted something important, and whatever list we made would be seen as final and authoritative and might actually constrain the rights tradition rather than enshrine it. But I knew that he was wrong, and so did the American people. It soon became clear that the people of the 13 colonies would not ratify this new instrument unless a Bill of Rights was offered by way of afterthought. Mr. Madison gathered some 88 proposed amendments from around the United States. He rationalized those to 18. 12 of them were passed by the First Congress of the United States. And on December 15, 1791, 10 of those proposed amendments were adopted as the Bill of Rights. In my opinion, the Bill of Rights is a more important document than the Constitution itself. The Constitution talks about the nature of elections and the difference between the House and the Senate and where appropriation bills must begin and under what circumstance a president or a national officer can be impeached. These are important questions, but they are not about the rights of man. The Bill of Rights is the most important document that we have to protect the natural rights we are born with all. And without a Bill of Rights, imagine how different American history would have been. Mr. Jefferson, what provisions did the Constitution make about the problem of slavery? Slavery is the besetting sin of the American Republic. The fact that we own slaves put us in a very disadvantageous position as we talked about the rights of man. The British cynic and essayist Samuel Johnson, perhaps thinking of me, said during this period, "How is it that the loudest yelps we hear for liberty come from the drivers of Negro slaves?" We were well aware that the ownership and the buying and selling of slaves was a blot upon our national virtue, and that we must solve this problem, if possible sooner rather than later. Now, I was not at the Philadelphia Convention, but I watched its deliberations with some interest from Paris. Slavery came up again and again and again, and it soon became clear that the northern states wanted it to be abolished, and the southern states wanted it to be enshrined in the Constitution. And at several key moments in the deliberations, the convention nearly broke down because of this fundamental social and legal impasse. In the end, the Founding Fathers decided that they could not resolve this question at this time and come forward with a new Constitution. And so a number of key compromises were made in the Constitution to enable the problem of slavery to be postponed for resolution to some future time. I believe the idea of slavery comes up 8 times in the Constitution, but never once by name. The Founding Fathers were that sensitive about the political backlash that might come from addressing so grave an issue while talking about freedom. But a number of famous compromises occurred. The 3/5 clause, for example, in which every 5 slaves are counted as 3 for the purposes of proportional representation and taxation. The Fugitive Slave Clause, which required people to return slaves that had escaped from their slave plantations, and a provision in the Constitution that postponed for 20 years any restriction of the slave trade. In other words, after ratification, 20 years must pass before the United States government addressed the slave trade in any meaningful way. I happened to be the President of the United States in 1808. I was serving my second term, and I noticed that it was now possible to restrict that execrable practice. I therefore suggested to Congress that they address the problem of the slave trade, and they did. And in 1808, we became the first nation in the world to outlaw the trading of slaves, by which I mean sending ships to Africa, buying slaves, bringing them in unspeakable conditions across the Atlantic Ocean, where 1 in 5 and sometimes 3 in 5 perished at sea, bringing them to this country and then selling them to the highest bidder, to men they never offended, for the profit and the economic efficiency of Southern planting life. We finally outlawed that practice in 1808. Slavery was so divisive, so fundamentally at odds with the principles of this country, that the Founding Fathers discovered that they could not solve the problem within their lifetime. And so these uneasy compromises postponed a permanent solution to that problem. And as you know, slavery was not outlawed in this country until after a civil war that consumed the lives of more than 700,000 Americans. Now that we have a Constitution, Mr. Jefferson, how should it be interpreted? Well, opinions vary on that, but I am a strict constructionist. I believe that the Constitution spells out in plain English what the government can and cannot do, and that governments must stay within that literal language of the Constitution. I'm a literalist. I believe that the Founding Fathers outlined the powers that they intended for the executive and the legislative and the judicial bodies of our government, and if they had wanted an elastic clause to enable government to do everything that it found useful at any given time, they would have written in such a clause, but they did not. And so my reading of the Constitution is that we can do those things that are specifically enumerated in it, and anything else that we may wish to do that's not included in the language of the Constitution itself should either be prohibited, or if we really think it necessary, we should write an enabling amendment to allow functions of government that had not been anticipated in Philadelphia. I became the most significant strict constructionist in my era, and my nemesis, Alexander Hamilton, was the great advocate of broad construction. And this came to a head during the great national bank controversy in the first of Washington's 2 administrations. Mr. Hamilton decided we needed a national bank of the United States. He therefore proposed it. George Washington, the president, was uncertain about this, and so he circulated a questionnaire to several members of the cabinet and asked us to weigh in on this. And I wrote a paper saying, "Our peculiar security is in having a written constitution. To take a single step beyond the bounds thus drawn by the Founding Fathers is to enter a field of boundless abuse, no longer susceptible of any constraint. In other words, we mustn't exceed the literal authority granted to us by the Founding Fathers." But Colonel Hamilton wrote a counter essay in which he said, no, this would make us the 3rd or 4th ranked nation, that we must have elasticity in government because things will come up that we could never have anticipated. And he pointed particularly to 2 clauses in the Constitution that he saw as providing sufficient elasticity. The first was from the famous preamble, the General Welfare Clause. And Hamilton said, by writing that the government existed for the general welfare of the United States, it effectively empowered legislatures to do whatever was required to promote the general welfare. He also pointed to a late clause in the Constitution, the so-called Necessary and Proper Clause. The Necessary and Proper Clause says the government can do whatever is necessary and proper to fulfill the enumerated requirements within the Constitution itself. On that basis, Hamilton said a national bank was constitutional. That struck me as metaphysics and little short of madness. But in the end, Hamilton got his National Bank of the United States. George Washington signed the enabling legislation. And that was the moment, I believe, when we shattered the sanctity of the Constitution and effectively permitted successive generations to do whatever pleased them by finding some clause or other within the document that could in some way be stretched to enable them to do whatever was on their minds. I continue to be a strict constructionist and believe that it is our peculiar security as a free people. Mr. Jefferson, you're known as a strict constructionist, but we also know that you purchased the Louisiana Territory from Napoleon in 1803. How was that constitutional, sir? Well, you're correct that the Louisiana Purchase was probably unconstitutional. I sent my ministers to France to buy the village of New Orleans or another port of deposit in the lower Mississippi, and we were prepared to spend $6 or $7 million to get that done. Napoleon, in one of the strangest counteroffers in human history, did not give me merely New Orleans, but offered the entire territory of Louisiana, 828,000 square miles, 575 million acres. When this news came to me in July of 1803, I was amazed, thrilled even, because this was the making moment of the American experiment. Now we had almost endless land on which to build family farms in small Republican states. And it also meant that we wouldn't have on our western flank hostile nations like France or Britain or Spain or even Russia. The American continent would be an American experiment, what I called an empire for the liberty, such as the world has never previously seen. But I also knew that the Louisiana Purchase was technically unconstitutional. And I wrestled with this problem over the summer of 1803. I actually wrote true draft amendments to the Constitution, one that would authorize the purchase of the Louisiana Territory, and the other that would authorize the incorporation of that new country by way of new states. And I wanted to promulgate those two amendments to the American people so that they could decide if they wanted to give us these powers or not. And if they chose not, we would have to renegotiate in some way with Napoleon and return the Louisiana Territory. But I never was able to issue those constitutional amendments. My Secretary of State and closest friend, James Madison, came to me and said, "Mr. Jefferson, Napoleon is showing signs of seller's remorse. He's changing his mind about the Louisiana Territory, and he's made it clear that if there's any protracted debate within the United States, that he will withdraw the treaty." I asked Mr. Madison what he thought I ought to do, and he said, "You should push forward to ratify the convention as quickly as possible, incorporate the Louisiana Territory, and we will finesse the constitutional question as best we may." And so that's what we did. But I want to remind you that that was a fugitive occurrence, the sort of thing that happens once in 1,000 years or once in 100,000 years. This wasn't a routine act of government. It was a response to the doubling of our republic with a single stroke of my pen. And so although I lost a little bit of sleep over the constitutional provisions of the Louisiana Territory, I never regretted that moment. And I feel that the purchase of Louisiana effectively guaranteed our national happiness, our virtue, and our economic success. Mr. Jefferson, how long did you think the Constitution would last? Well, that's a great question. Different people had very different views of this. When George Washington, who presided over the Constitutional Convention, was asked how long he thought the Constitution would stay in place, he said, well, 20, maybe 25 years. Ben Franklin, upon leaving the Constitutional Convention, was asked by people outside who had no idea what had really transpired there, "What have you produced, Mr. Franklin?" they said. And the wise old man said, "A republic, if you can keep it." I wasn't there. I was in Europe during the writing of the Constitution, but I was asked many times what I thought its longevity ought to be, and I gave the most startling and I suppose radical answer. On the basis of the principle of consent of the governed, I believe that each generation has a right and a duty to draft its own constitution, that no law, no national debt, no constitution can be perpetual because the people who created it have passed from the scene. I wrote a letter to this effect to James Madison while I was in France and said, "I don't know that it has ever been properly understood that the earth belongs to the living, not the dead. The dead have no rights, and the dead must not be permitted to lord it over generations unborn. Each generation has the right to govern itself according to its own best lights and according to instruments of its own drafting and ratification." Therefore, I suggested to Mr. Madison that we tear up the Constitution of the United States once every generation. And from actuarial tables, I worked that out to be about 19 years. Accordingly, I thought we should tear up the Constitution once every 19 or 20 or 21 years, bring together a new Constitutional Convention of American citizens, and write a new social compact for that time and that place with its demographics, its technologies, its challenges, and everything else that matters in these deliberations. There can be no perpetual Constitution. Needless to say, Mr. Madison was not impressed by this line of logic, and he said to me, "If you had any idea, Mr. Jefferson, how difficult it was to get the first Constitution, how many times the Constitutional Convention nearly broke down, how many impasses we had to push through with some sort of compromise to go on, You would not, my friend, be eager to do this very often. And he said, there is a certain majesty that is required in a constitution, and if you tear it up too often and start fresh, you will lose that fundamental reverence for the law, without which there can probably be no settled public order. And so I slowly came to terms with the idea that the Constitution would not be torn up once per generation, but I did think that it should be frequently amended and from time to time completely revised. Mr. Jefferson, who is the best arbiter or judge of what the Constitution intended? The way things have worked out in American history, the Supreme Court is the final arbiter about constitutional questions. And every spring in the United States, the American people wait for the Supreme Court to issue its pronouncements about this or that law that has come up to its attention. I disagreed with that from the beginning. These judges, in my time 6, in your time 9, are not elected by the American people. They don't stand for re-election, and there's no vote of confidence or no confidence in the course of their tenure. And their tenure, I remind you, is for life on good behavior. So once a Supreme Court justice has been nominated and confirmed by the United States Senate, he serves for life. That could be 15 years. It could, in your era, be 50 years. And yet there is no provision in the Constitution that enables a bad Supreme Court justice, one who is senile or ill, to be removed unless he has committed what are known as high crimes and misdemeanors. So life tenure is a bad idea in my view because it's anti-democratic, and it keeps in the courts people who long since should have retired to private life. But even if that weren't true, I do not accept the courts as the final arbiter of constitutional provisions. It seems to me that the people themselves are sovereign, and of the 3 branches of our government, the legislative is the one closest to the people. Indeed, in the legislature, the House of Representatives is even closer than the Senate because it's re-elected every 2nd year, and there is not an identical number of representatives per state. And so it seems to me that we need to spread constitutional interpretation around. I actually felt that each branch should judge the Constitution according to its own lights and its own theory of government. And I even suggested that the states and the governments of the states have a right to respond to national legislation. For example, when the Adams administration passed the palpably illegal alien and sedition laws of 1798, the courts of the United States made no attempt to stop them, even though this was a fundamental violation of the First Amendment. So I went back to Virginia and secretly drafted something known as the Kentucky Resolutions, which were passed by our neighboring state of Kentucky, in which that legislature said when the national government of the United States exceeds its constitutional authority and no one of the 3 branches checks that abuse, the remedy must be for the states to protest, maybe to refuse to enforce those illegal laws within the boundaries of a state, and maybe to threaten secession under extreme circumstances. This is known as nullification. Kentucky passed those resolutions and made it clear that when the national government becomes abusive and exceeds the authority granted to it by the people, that if nobody else checks that power, then the states are the last melancholy attempt we can make to restore order and to keep government within bounds. The remedy otherwise is secession or civil war. Mr. Jefferson, executive orders have become a controversy in our own time. What was your attitude towards them in yours? The Constitution does not make any provision for the President to write executive orders, and yet from the very beginning they have been a part of our national life. But in my time, I did 1 or 2, and George Washington did a handful. Our executive orders were procedural. They were about when Congress would meet, or what constitutes a quorum, or other things that had to do with the mere structure of our government, the way the cabinet was set up, or the way different cabinet officials held their portfolios. In other words, we did not ever use executive orders to create policy or to weigh into affairs that really belong to the legislature. I believe very strongly that of the three branches, the legislature should be the most powerful because it's the branch that actually leans on the people who are the sovereign. Whenever the executive goes beyond those powers enumerated for him in the Constitution, he has committed, in my mind, impeachable acts. And so as president, I stayed very firmly within the boundaries of power that had been granted to the executive, and I would have fought any attempt by later generations to aggrandize the presidency towards some sort of imperial rule. If executive orders are being used in your time effectively as legislation from the executive branch, that strikes me as moving towards monarchy. And if I were alive in your time, I would do whatever it took to check that sort of power, including impeaching presidents who abuse it. I'll do one more, unless you can think of something. Under what circumstances, Mr. Jefferson, should the president veto an act of Congress? My theory of this is quite strict. I wrote a letter to George Washington when I was his Secretary of State, and he was considering vetoing legislation that he thought was not in the interests of the country. But I said, no, unless you feel that the legislation is unconstitutional, you should withhold your veto, because if we truly believe in legislative supremacy and the Congress of the United States passes a bill that you think is a nuisance or unduly expensive or not the best policy for this country, it's not your role as president to check that. Your role is simply to maintain the Constitution itself. And you should remember, Mr. President, that you are only one official, and Congress consists of several hundred people from all of the constituent states. If the people are really sovereign, they have a right to enact whatever legislation they please, so long as it does not violate other provisions of the United States Constitution. So I would be for a very restrictive and narrow use of the presidential veto, and never under any policy concerns. In fact, I was President of the United States for 2 terms between 1801 and 1809, and on no occasion did I veto an act of the legislature. Mr. Jefferson, if you had had your way, what provisions in the Bill of Rights might you have added? It's true that I was, in a certain sense, the bibliographer of the Constitution, and the letter that I wrote to Mr. Madison insisting on a Bill of Rights probably had something to do with the creation of that document. But I didn't write its provisions myself. Had I been the author of the Bill of Rights, I would have added several provisions. First, I would have prohibited a national debt. It seems to me that a national debt is a national disgrace. It's a way of taxing our children and our grandchildren without their consent. And so the first thing I would have prohibited is a national debt that is not paid off entirely by the generation that undertook it. Secondly, I would have enabled certain citizens to object conscientiously to serve in the militia. I believe that all citizens should serve when called upon by their government. That's part of the social compact. But there are people like our Quakers who are not willing to wage war. And if that's the case, it would seem to me to be a violation of their rights of free religion. It would violate the sanctuary of their conscience to force them into military duty. And so I wanted a provision that would enable us to exempt certain citizens who could prove that they had philosophical or religious objections to service in the militia. I also hoped that we would have a provision limiting terms of national officers to no more than 2. And actually, in thinking about this, I once suggested that we have a single presidential term of 7 years with no chance of re-election and a vote of confidence or no confidence in the middle. But under any circumstances, I believe in rapid rotation in office, and I'm against careerism in all of its forms. And so I suggested that we have a 2-term limit for all national officers, enshrined by way of constitutional amendment, and probably that we have some mechanism of voting confidence or no confidence for Supreme Court and other federal judges. Life tenure, it seems to me, is a very quixotic notion, and it seems to me you cannot be a democracy or a republic if the people cannot retire in a pretty consistent way those who are no longer serving the interests of the people of the United States, I probably would have amended the impeachment clause a little bit. As you know, the impeachment clause says that national officers can be impeached for high crimes and misdemeanors. But there are cases where a national officer should be impeached for gross incompetence, or for physical debility, or senility, or some other malversion of his public life that does not rise to the technical level of high crimes and misdemeanors. There was, for example, a New Hampshire judge by the name of John Pickering who was a drunkard and was given to bouts of insanity to the point that even his family asked us to relieve him of his duties. And we did. We did impeach him, and he was convicted by the United States Senate. But it was a bungling sort of business because he had not committed high crimes or misdemeanors. And so it seems to me that we ought to have a somewhat more elastic clause on impeachment so that we can protect ourselves from demagogues or gross incompetence or corruptions that are not illegal but nevertheless obnoxious to the spirit of liberty. And finally, I would have had an amendment that insisted that the Constitution be revised every 5 or 10 or 15 years and torn up once every generation. In spite of what I regarded as some of its weaknesses, I do think the Constitution of the United States is the best ever created by human agency, and I was fortunate to preside over this country for 8 years of peace between 1801 and 1809. And I said later in life that constitutions come to have a sort of sanctity which may not be in the best interests of the people. In 1814, a man named Samuel Kercheval wrote me a letter asking me about changes that were being suggested for the Virginia Constitution. And I wrote back a famous letter in which I said, "Some men look on constitutions with a kind of sanctimonious reverence and deem them like the Ark of the Covenant, too sacred to be touched. They ascribe to the men of the preceding age a wisdom more than human and assume what they did to be beyond amendment." I said, these constitution makers, men like Franklin and James Madison and Alexander Hamilton and George Washington, deserve our respect. They gave us a fine constitution. But I also said 40 years of experiment in government is worth a century of book reading. Our basic instruments must go hand in hand with the progress of the human mind. We may as well require a man to wear the coat that fitted him as a child as to require our civilized citizens to live under the regimen of their barbarous ancestors. And so I urge you, my fellow Americans, to be bold about your Constitution, to amend it when it ceases to be useful to you, and to tear it up from time to time to start fresh. Each generation deserves to govern this country according to its own instrument and its own dreams of American happiness. Thanks for listening. I'm Thomas Jefferson.